Hey guys, there's nobody here, but hey guys, anyways. There is people here. Okay. Hi. So, this is part 2 of the Phil Spector trial, and yesterday was the opening statements from the state, and today we're going to do there's a little something that is done outside the presence of the jury. I don't know what that's about, and then we're going to start the defense opening statements, which is very long for some reason. There's like 3 parts. We're going to do part 1 today. Hey, Carla. And as always, I'm going to try to leave my camera on, but hey, Lori. But if it glitches, I will turn my camera off.
You indicated you wanted to make sure that the defense did not reference certain statements that have been made by the defendant at a certain time.
Your Honor.
All right, go ahead and articulate.
In an earlier hearing, that Mr. Sortino was standing where I'm.
Mr. Dixon, you indicated you wanted to make sure that the defense did not reference certain statements that have been made by the defendant at a certain time.
Your Honor.
All right. Articulate.
In an earlier hearing, that Mr. Sortino was standing where I'm standing. The whole issue of the defendant's statements made at the time is my understanding, and I think we've brought this up since then, that the court ruled that those were 1220 statements, that they would only come in if the prosecution offered them. And if the defense offered them, they'd be hearsay statements. We just wanted to point that out again, since Mr. Jackson did not mention those in his opening statement.
Why does StreamYard hate me so much? I don't understand. See, all I have to do is turn my camera off and the picture comes back. Maybe StreamYard thinks I'm ugly or something. I don't understand.
Yeah, police officer Page. I didn't know till now, until this moment, that he wasn't going to use these.
Hey, Randy.
With Officer Cardella and Officer Rodriguez and some other officers present, which is, to me, Your Honor, what I thought we argued when Mr. Sortino was here. It begins with, what the heck is wrong with you? It's a statement that indicates that occurs right after Mr. Spector is tasered, tackled, knocked down with a ballistics shield, and handcuffed. And right as soon as that occurs, these are the statements they record. It also,
I need to know what
the specific, okay. What the hell is wrong with you? This dovetails with the prospective testimony of Beatrice Rodriguez, a police lady, police woman. What the F is wrong with you? What the hell is wrong with you? I can tell you what happened. Just tell me what happened. What the F is wrong with you? What the hell is wrong with you people? Oh, Jesus Christ. I'm sorry there's a dead woman here. I'm sorry, but this happened. I can explain it, but if you just give me a chance. And at page 6, I can tell you what happened. You don't have to handcuff me. I can tell you what happened. I'm sorry this happened. I don't know how it happened, but it happened. I'm sorry this happened. But I don't need to be tied up like a pig. Page 7. The gun went off accidentally. It was a mistake. Do you have to step on my back? I'm sorry this happened. I don't know how it happened. It scared the ever-loving life out of me. I'm not used to using harsh language, Your Honor. It says...
You're paraphrasing.
Yes, I am, sir. I'm not used to doing that. I'm sorry this happened. Oh, dear God. This is the most devastating thing I've ever seen in my life. Are you arresting me? And then it ends at page 10 with the police officer, Hammond, talking about taking out one of the tasers from Mr. Spector, I believe. So those are the statements, Your Honor. I didn't know till just this moment. I don't know for some reason. I didn't know that the prosecution team were not going to use the statements made at the castle, taped by Officer Page. And also, Your Honor, there's the statement, so-called statement to Beatrice Rodriguez, subject of a pitches motion, which was not taped. And then we have Judge Fiddler statements back at the Alhambra Police Station to Detective Panetta regarding a self-inflicted gunshot wound. This was also testified to in the grand jury. There are several statements in here that I wanted to adduce from, I think it's Esther Panetta, police woman.
Look, I can't rule unless I know the content.
Yes, sir. May I begin, Your Honor?
Yes.
Page 17, this is Mr. Spector. What's happening to my house, Mr. Spector? I mean, what happened? What happened at my house? How do I find out what is going on? Mr. Spector, I can tell you what happened, but I can't tell anybody what's going on there now. And then there's some conversation between Officer Panetta. I'm sorry, Your Honor.
Well, let's be honest. I realize that's your normal tone of voice, but it's loud, and I'm just wondering if I'm concerned that the jury may be able to hear you. That may be why they're buzzing. Just hold on a second while Chandra checks.
I gotta go to the soda voce, Your Honor. I promised you I would, and I'm going to do it.
I'm only concerned if the jury can't hear us, there's no problem. But if they can, then we'll have to find a different way.
That's a first. Usually they're not talking loud enough.
I'll come down anyway. I'll come down anyway. Page 18, Your Honor. How do I find out what is going on? Well, I went through that. And then in the middle of page 18, when Mr. Spector is informed that he's being arrested for murder, he asks, murder of whom? This is the most bizarre nonsense, and this is absurd. This is absolutely absurd. And then it goes on to page 20, which I outlined for the opening. This is nonsense. You people have had me here for 6 effing hours, maybe 9 hours. You have locked me up like a goddamn effing turd in some effing piece of S. You treat me, and then while this person eats, etc. When somebody comes over to my home who pretends to be security at the House of Blues and comes over to my home where this lady pretended to work, I want to be forthright, okay, and then blows her head open in my home, and then you people come around and arrest me, bang the S out of me, out of my effing ass, and beat the S out of me, and then you pretend and arrest me, and then pretend like you're effing Alhambra. Then at page 21, I don't know what the lady, what her problem is. She wasn't a security at the House of Blues. He makes a derogatory remark there. I don't know what her problem was, but she certainly had no right to come to my castle, blow her effing head open, and ... a murder. What the F is wrong with you people? It scared the S out of everybody while somebody commits suicide. So that is the portion of the second delineated conversation that was taped. And the third one, Your Honor, is the statement to Officer Gilliam, Gilliam. Maybe it's Gilliam. His testimony, which we expected to adduce, is consistent, again, according to what Officer Gilliam said, and he testified, I think, to it in the grand jury, if I'm not mistaken, that he came in to see Mr. Spector, who mimed, M-I-M-E-D, mimed, if you will, through a suicide, self-inflicted gunshot wound pattern, and it so troubled Officer Gilliam that when Mr. Spector's head went back, Officer Gilliam being handcuffed, taken to the Alhambra Police Department station, the statement there to Detective Esther Panetta, and the statement to Officer Gilliam. These were part of the motion to suppress we had a couple of years ago, I believe, or maybe a little bit less than that. We argued about these statements. I know I didn't receive a written order from the court, but we argued to suppress the statements because Mr. Spector had asked for a lawyer when he was at the castle. So I thought the court had ruled, yes, he had asked for a lawyer, but these were excited utterances, if you will. They were spontaneous declarations, if you will. They were coming from him not as a result of custodial interrogation, but they were volunteered by him. I understand the position of the prosecutors, but this is part and parcel of the heart and soul, a part of defense.
I appreciate that, but I'm listening for a basic admissibility.
Maybe I could help you.
Well, I've spoken to Roger, who's the California expert. Even under the doctrine of completeness, which 356 is the number.
Now, 356 deals with, in this case, it's separate statements. They don't come in as part. It's not part of the same conversation.
Your Honor,
The only thing that people have offered so far at this point is a statement, which can be considered an admission, perhaps a confession. It depends, and that's for the jury to decide what it actually is when they're appropriately instructed. But the only people who can offer an admission are the party opponent. In this case, not Mr. Spector or his counsel, but the other side, the district attorney. You can't offer it. It's hearsay as to your side.
a statement made by a defendant being charged with murder and tape in California is ruled hearsay?
certainly.
That's why
Unless the other side offers it, and they're not offering the conversation.
well, I didn't know that until just this moment.
I appreciate that, and if you need time to sort of regroup for a second and, so that you can appropriately argue, that's fine, but I still haven't heard a theory of admissibility.
The theory of admissibility for me is twofold, Your Honor. Putting aside the fact that the prosecutors are not bringing it out, it is, and I don't want to repeat myself, but these are statements made by a defendant who's being accused of murder. And even if the prosecutor doesn't use them, if he takes part of a statement, which he's using with part of a statement which he's using with D'Souza.
That's a whole different statement.
I appreciate that, Your Honor, but we've geared the jury to thinking about corroboration. We've geared the jury to thinking about what Mr. Spector said that's on tape that had been recorded and memorialized, as opposed to the statements made to D'Souza, which are not corroborated, which are not memorialized, and which are not reliable, in our opinion, for some other reasons, which go to weight, not admissibility. I know, Your Honor. The prosecutor may argue that the 911 tapes corroborate what D'Souza said, and I understand the argument. For me, they're excited utterances, they're spontaneous declarations, and they certainly go to the state of mind of Philip. I'm certainly getting aid and help from California expert counsel on this. I was operating under the impression the court had ruled they were admissible. I thought Mr. Jackson and Mr. Dixon were going to introduce them. So I'm not floored. I'm just taking a little back.
Just rocked.
Yeah, just a little bit rocked, and I'll get back up. I just wanted to make the record for you, Your Honor. I know you as a former trial lawyer understand more than anyone. Other than, may I have a moment, Your Honor?
Sure. You want to consult with
Yes.
your co-counsel?
Probably can't read my hand.
I can. Yes, this goes along with, to me, an equity and fairness rule, which I know they have here in California. They have it in New York, and a completion, doctrine of completeness as well. The prosecutors opened the door, and I think this is Mr. Jackson, by saying that Mr. Spector did not say or act like a person who was concerned that somebody died in his home. And I, ab initio, have been, at least the 2 days I was up, last Monday and Wednesday, have been going over with the jurors that the decedent died in Philip's home, at her hand, not his. And science will back that up. So now we're at, to me, a tactical and trial disadvantage, because the impression is left with the jury that what Mr. Spector did was kind of, he didn't say it, but kind of evidence of consciousness of guilt, even though I dub it consciousness of terrorized innocence, and also mentioned about the 14 telephones and didn't call 911. When you leave that impression with the jury, Your Honor, most respectfully, at least from our vantage point, they're getting 1/3 of a story when 3/3 would be the complete story. And that's where my argument is. I can't cite you.
Yeah, and you haven't even done your opening statement yet. That's what opening is for. So why are you arguing about state's opening when you haven't even given yours yet? What? Oh my God.
Case because we haven't researched it, but I'd like to be able to do that. And today was the first day, and that I heard Mr. Dixon echo this change in trial tactic. I didn't expect it. I don't know how else to expound upon it. It just seems to me under everything we said, Judge, the jury is being misled about what happened at the castle. Mr. Jackson also said he was uncooperative, and he was cavalier. He didn't make phone calls. He was uncooperative. I want the jury to know what happened. Mr. Spector invited them into the house. He may have been in shock, But one of the tapes begins with, you come in, you have to see this, please. And not coming in, they asked him to raise his hands, and he did once, and then they asked him to raise it again and again and again, and he didn't. And then the tasering began, and the tackling and the rest of it. I remember arguing this, and I also, I'm told by Mr. Rosen, that section 356 is the same subject matter. Is that the idea?
Yeah, could I just,
Sure. Is that it?
I think that's a misstatement of law, Mr. Rosen. I hear you. That is a misstatement of law. It isn't just the same subject matter that allows it in under 356. It is. That's not the law. I can show you, I'll be happy to get you cases, I don't have them up here at the bench, where a person basically, the prosecution, for instance, offers a statement, and there's a brief pause, as little as 2 minutes. And then another statement is made which the defense wants in. And they try to get it into 356 because otherwise it's hearsay. It's not admissible. It's not even considered the same conversation. It's not the same subject matter. That is not a 356 objection.
Your Honor, but a statement?
I'm going to rule on all your.
Yes, but a statement by a man being arrested?
I'm going to talk about that if we can move forward. I think Mr. Brunon has a late order for you.
Let him say it. Could we have 2 minutes to take?
I'll give you 2 minutes. We'll be in brief recess. All right, thank you. Yes, Mr. Rose. Remember, we're going to have, I understand that you want to consult. I'm not going to have 3 people address me on the same issue. And I understand you have a lot of lawyers. You're welcome to everybody you want, but only one person's going to make it.
Yes, perfect.
All right, you can have a couple minutes. All right, back on the record, the jurors and alternates are not present. All right, if you'd like to add anything, please do.
Yes, sir.
Okay.
You want to, got some great help from Mr. Rosen and Mr. Brunon and even, and of course, Mr. Gordon and Ms. Kenny Biden. Your Honor, I cite the court to section 1240 and 1241, the spontaneous statement. Evidence of a statement is not made inadmissible by the hearsay rule if the statement, A, purports to narrate, describe, or explain an act, condition, or event perceived by the declarant. Would be Philip. B, it's an and, was made spontaneously while the declarant was under the stress of excitement caused by such perception. So that's the first section. The second one is 1241, evidence, a contemporaneous statement. Evidence of a statement is not made inadmissible by the hearsay rule if the statement A is offered to explain, qualify, or make understandable conduct of the declarant, and B, was made while the declarant was engaged in such conduct. Your Honor, so that's the first part of the argument, why it should come in. The other part is, in opening statements, we've been guided by the court's ruling that the evidence will show, we will prove that, the evidence will show that. So we have to stay away from speculation. So an opening statement is not evidence. So I'm prepared and was prepared, and part of my opening was to show the statements that put the other statements, the other statement that they used at least, in context. In addition thereto, Your Honor, they mentioned the 911 and the 14 telephones. They mentioned the totally uncooperative, et cetera.
But they didn't mention any specific conversations.
They didn't mention any specific conversations once Alhambra came in force. No, they did not. But they created the impression that something happened that didn't. And Your Honor, I mentioned this before. I've been with these great lawyers. There's so many of them. They just they come at me in the best of ways. Come on in. You've got to see this. Goes to what I mentioned to you before. That this was not an uncooperative stance. There was no consciousness of guilt. As a matter of fact, it was Philip at the door who beckoned to the Alhambra folks to come in. I mean, he didn't call the police, I understand that, but he did say, come in, you've got to see this. So those are some other explanation. You must see this, there's a dead woman here. So it's not coming in for the truth per se, in that's another aspect of it. It's coming in for state. Last and most important thing, Judge, as an out-of-towner, I'm about to get up, deliver an opening statement. And I think this kind of thing, and I'm not casting aspersions, but this kind of thing should have been subject to some in limine ruling. I did read your minutes, I read your ruling, but we all expected to go into this today. So when we approached, I would have done it in my opening. So when we approached you, Judge, I found out today for the first time from Mr. Dixon that they object to that. So I am denuded of much of what I wanted to go into at the last second. And in due process and fairness, this should have been done when we had our in limine day before we started voir dire. So that's the other reason why I've been kind of, not low, but I've been led down a particular path here, and now it's foreclosed. I don't think that's fair or right in an opening statement to do that. I don't have to go into the in hoc verba Q&A, but I can go into the broad brush aspect of it, that he made these statements that are, well,
Go ahead and
that
finish
he
your
made
presentation.
these statements to the police, and they are all consistent with him pleading not guilty, that this was self-inflicted, that he played no part in the death, and that is our defense. That's always been our defense. Now, the science is some of the meat and potatoes in our defense, Your Honor, but it's always been our defense that the things he said that were recorded were part and parcel of the muscle in our defense, because they were all, I don't want to say consistent because that will move you away. They were all part of our defense. And it's not until a few moments ago that I found out that the prosecutor is not introducing the Beatrice Rodriguez statement, from what I understand, which is their prerogative, I imagine. But now they've gone further. They've gone and they've said, we are precluded now from mentioning the statements that Mr. Spector made, after they argued so vociferously, without saying consciousness of guilt. That's what they argued. They argued it forcefully about the cleanup, the 40 minutes, the not making the phone calls, the doing nothing, being uncooperative. They created an impression that's not true, not accurate for us. So under 1240, 1241, opening statements, and all the other things that I mentioned, and I asked that the court reconsider. In addition thereto, I spoke to Mr. Ford, Mr. Brunon, and Mr. Rosen. We'd like to submit something on this, Your Honor. And I don't want to be hamstrung at this point at 3 o'clock now to strip my opening statement and just to go forward. I don't think it's a fair thing.
Okay.
I don't think it's fair. That's all I'm saying.
All right.
I'm not angry, Your Honor. I'm just taken aback.
I didn't think you were.
Yeah.
Okay. Anything else?
No, sir.
Let me try to, if I don't mention it specifically in my ruling, doesn't mean I haven't considered it. I'm just trying to recall specifically the arguments that were made. First of all, working backwards more or less, you indicated in New York, which I do not have knowledge of New York law, but you mentioned an equity and fairness, either argument or statute. We have no
Due process, Your Honor.
Well, while we have equity, we have fairness, and we have due process in California, we don't have it as a statute in the evidence code that would allow under those headings for you to introduce otherwise inadmissible statements. So it's not coming in under that guise, if you will. You've indicated that you want it introduced as Mr. Spector's state of mind. His state of mind when he made those remarks is not relevant. Sometimes state of mind is relevant and serves as an exception to the hearsay rule. Not in this case. Under 356, and I want to reiterate, although same subject matter is part of the statute, it has to be part of the same conversation, and that's why it does not come in under 356. It is not the same conversation. As far as contemporaneous and or excited utterances under 1240 and 1241, does not qualify. It does not go to explain the event. It goes to explain the crime, but that is not the event that caused that those sections go to under the facts of this case, it's not admissible. It's admissible only if the people choose to introduce it, in which case you have a right to introduce the entire conversation. If they introduce a conversation, you can introduce all parts of it. If they don't, that's what 356 goes to. There's no legal or evidentiary basis to admit these statements. They're inadmissible under California law. They're hearsay, with no exception. Now, as far as the one additional thing that the prosecution, although certainly had they had the concern earlier, and I don't know when the concern arose, they should have or could have certainly raised this in an earlier time. But the bottom line is they don't have to presuppose what your opening statement is going to be, and they're not required to do anything except object if you make it. In this particular case, they asked that it not be made, and their objection, if you will, was an anticipatory one that was delivered just before you gave your opening statement. I can't say that I'm completely thrilled by the timing, gentlemen. It might have been nicer if you knew this was going to be an issue, and I don't know that you knew it was going to be an issue. Mr. Dixon, would you like to respond? Yes.
We did.
Okay.
In preparing for this, we reviewed the court's transcript from October 27, 2005, where the court heard motions from the defense to suppress these statements, and at the same time, the court said conversely, basically, these statements are 1220 and they should only come in. At the time of our 402 hearings, on April 10th, Mr. Jackson stood up and said, we'd also like to confirm that these statements are only admissible if we offer them. And the court said, yes, of course, and we moved on quickly, but we brought that up at the time. As the court recalls, you asked us to deliver a PowerPoint presentation to the defense, and we did that. It was at the beginning of today, but we did that. There's no mention of the statements here at all. So this is not quite the surprise I think Mr. Cutler believes it is. We tried to, we didn't say we weren't going to use the statements, but we did have you confirm your ruling on April 10th, and that's why we did it. I don't know if we need to telegraph our whole trial strategy to the defense, but that's exactly why we did that on April 10th.
All right, thank you. In any event, for the reasons stated, the statements of Mr. Spector are not coming in at this time. They will not be as part of your opening statement. I don't believe they're admissible under any possible authority or theory at this time, depending on what the prosecution presents. That might change. But at the present time, you are to refrain from offering those statements. And although you indicate that you have been surprised, certainly it's easier to take something out. You're going to need to go forward with your opening statement. I don't think it's going to be concluded based upon the time estimate you gave me, but you'll need to start your opening statement. We're going to bring the jury back. If you need a couple more minutes just to rethink how you want to present it, that's fine, but I'm not going to break for the day.
Your Honor, can we at least,
You want to submit something later, that's fine. You can submit something more.
may I use the men's room?
Yes, you may use the men's room. And we will resume when you're done.
Yes, sir.
All right. Quiet down, ladies and gentlemen, please. Thank you. Back on the record, the jurors and alternates are not present. All other parties are. Mr. Cutler?
Yes, Your Honor, I wanted to invite the court's attention. May I approach
Yes.
this? Your Honor, the statement, the page statement, which I read to the court, which I expected to be part and parcel of my things, of my opening, has an invitation, if you will, by Mr. Spector to please come in. You've got to see this. The whole theory here has been changed because I'm unable to refute something that is misleading and untrue. So I feel like my pants are down and I'm naked before the court. I don't want to be overly dramatic, but we have a theory and a theme which now is strict, at least for the opening. And I don't want to just make introductory remarks, Your Honor, and waste the court's time. The court's time is too valuable, so is the jury's time. But all of this is part of a theme and a theory that I've woven. I don't just get up and I don't want to say move from the hip, if you will. But we have developed a theme of defense. It is now at least for me, has been changed drastically for me. I can't say that everything Philip said is consistent with self-inflicted gunshot wound, because it may be the things that he said that are consistent are not coming in, at least not right now. In addition there to the so-called invitation to the police, which refutes the uncooperative aspect and the consciousness of guilt. I don't know how to
The
repeat that
statement,
without.
excuse me, I'm going to interrupt you for a second, and I don't like to interrupt, but the statement, you may come in, that's admissible. That I have no problem with that. It's not an admission. It's basically, it does to the extent that he was uncooperative. You can, and I'm not sure that's exactly the nature of the statement. You may introduce the statement that he said to come in. That's fine. So you don't have to worry about that. And we can move on to
I
something else.
understand, Your Honor, but that doesn't help me with my opening. I don't have a piecemeal opening. I have a thematic opening that is now eviscerated for me at this point. So I don't know how to go forward, Your Honor, unless I regroup and go through this again. I mean, I have all of this laid out. That's why I brought all of this with me to go into this, because it's so important, I thought, and I still think it is. It also, it now puts the onus on us to feel that we may have to, of course, maybe premature, but object to the stand if we're not planning on doing it. If we don't want to do it, if we don't need to do it, and it's not something we're married to one way or the other, but it throws the onus on us. So now what happens with the Alhambra police when they testify? We can't ask them about these things? They're just going to say that they tasered him, knocked him down, and handcuffed him, and we can't go into all the statements that he made?
That's correct.
It's one-sided, Your Honor. It's completely unfair.
It's called the law.
Your Honor, I would like to have known it before today. That's all. And I'm not blaming you. It's just, it puts me in a terrible disadvantage. That's all I'm saying. It does. I'm not going to repeat it. It puts me at a disadvantage, and I've worked under them before. But I wanted to, at least you know how I felt.
Okay.
I wanted you to know we wanted to submit law on it. And for me personally, I wish I would have known it before this afternoon.
Okay.
So that's where I am.
All right. I thank you. I appreciate that. But with all due respect, and I realize that you may not be as familiar with California law as some of the other attorneys because you don't practice here on a regular basis, but you're presumed, and the defense team is presumed to know the law. These statements are inadmissible. They have been ruled previously as inadmissible. They cannot be used in an opening statement. And although you may need to regroup some, there's 45 minutes remaining today's session. You can argue for 45 minutes. I didn't expect you to finish. And if you want to come back tomorrow and finish your argument, if we go to 4 and you haven't completed it, that's fine. All right, let's bring that to jury.
Sir, yes, sir.
All right, thank you. That's thanks for that, but that's not necessary.
Yes, sir.
All right.
Okay, so now we're going to watch the first 45 minutes of defense. So I guess I stand corrected. He's not allowed to say. I thought that he could just get up and say those things in his opening, but apparently he can't because he's not allowed to. But just let me ask you one thing. Who does that to themselves with the purse on their shoulder? She was ready to walk out the door.
All right, the record will reflect that the jurors and alternates have returned to the courtroom. And ladies and gentlemen, thank you so much for your patience.
Why are you buffering? All I did was make you full screen. You were running fine. What do you mean video in bad format? I'm playing it off of Court TV's website. What do you mean bad format? Oh, for crying out loud. Okay, this time it's on Court TV, not me. Don't tell me we can't watch this. I will write a strongly worded letter to Court TV if we can't watch this.
All right, the record will reflect that the jurors and alternates have returned to the courtroom. And ladies and gentlemen, thank you so much for your patience. I would love to be able to tell you it's not going to happen again, but it is. I think I forewarned you that at times the legal arguments are going to be lengthy, and all we can do is put you in the jury room and make you as comfortable as we can. And with that in mind, Mr. Cutler, you may proceed.
May it please the court. Ladies and gentlemen, good afternoon. I haven't spoken with you since last week. I think it was on Wednesday of last week, so it's been a week. As you know, I'm Bruce Cutler, and I've come here to represent Phil Spector in this very serious matter. In my opening remarks to you. Those photographs we saw, the remarks we heard from Mr. Jackson are not evidence. Photographs are, the remarks are not. It seems from Mr. Jackson that he has from his opening statement, which is not evidence, a very negative view of the Spector. It seems from Mr. Jackson's opening remarks that he has depicted and described him in the most negative of terms. So it becomes a problem to alert you to what evidence will show. Part of what the evidence will show is that being successful, accomplishing such, achieving so much, doing so much for when we do so much can come back to hurt you. Your car is too nice. Restaurant is too nice. The evidence will show. Manhattan, Carlisle is too nice. The evidence. Fame and success.
What does that even mean?
The evidence will show this was a tragic accident. It's a sad thing for any jury to see photographs that you saw. And the evidence will also show that back on February 3 of 2003, before they even had a cause of death, let alone a manner of death, they had murder on their mind. Murder on their mind.
Sorry, guys. I like both. I like bald and long hair. when we first got together, I saw pictures of him with his hair not like down his back, but like to his shoulders, and he has curly hair. So when it's longer, you can see the curls. And I tried to get him to grow it out, and he wouldn't. He said it doesn't do that anymore. Whatever.
Full of snacks and cookies and water and sound asleep, sitting in a closed car with the heat on and the radio on and the fan mention the evidence will show, he was able to be startled enough and to hear those 5 fatal words. I think I killed somebody. I think I killed somebody. I think somebody is killed. Or maybe he didn't hear anything. Because according to the evidence will show that but when I say to you, ladies and gentlemen, murder was on their mind, this is what from Detective Fournier, I hope I'm pronouncing it right, and Tomlin, but I think it's Detective Fournier, Fournier, to De Souza in an interview in Alhambra on the 3rd of February, right after this incident. Quote, this is going to be a high-profile case, no doubt about it. He's a man with a lot of money. He's wealthy, and it's going to be considered high profile. It's going to be in the news. It's going to be a big thing. And De Souza says, what do I have to do? And the detective says, tell the truth. And De Souza says, I want somebody to direct me. And the detective indicates, what you saw, what you heard. That isn't going to change tomorrow, next week, next year, or down the road. What I'm getting to, ladies and gentlemen, is that by the time Alhambra responded to the home, and by the time they spoke to De Souza, they had delineated and described this case as a murder. It had no alternative in their mind. It had no alternative in their mind. If the evidence shows you that the decedent, who's 5'11", was 5'11", 161 pounds and almost 6 feet in heels, and who was familiar with guns and firearms, and the evidence shows you that, and we prove that to you, and the evidence indicates to you that this was a self-inflicted gunshot wound, that at the time of the discharge of the weapon, of the gun, it was in her mouth by her own hand, not by Mr. Spector's. And if science proves anything, and we prove to you that Mr. Spector was at least 2.5 to 4 feet away at the time of the gun discharge, and if you find from the evidence that
No, it's not argument.
the evidence will show that at the time of the discharge, from what we've seen and what we've heard, the decedent fired the gun herself. And I'm not suggesting to you, and I'm not saying the evidence will indicate to you that this was a suicide, but a self-inflicted gunshot wound, ladies and gentlemen, can be an accidental suicide. And if the evidence, and I submit, the evidence will show you that's the case. And the way we started today, early this morning, was that Mr. Jackson, who was taking Mr. Spector to task for being successful, said he ran with a haughty crowd. Haughty, H-A-U-G-H-T-Y. That means arrogant, supercilious. He doesn't run with, the evidence will show he didn't run with any haughty crowd. The evidence will show that Philip was born in New York, as I was, a city boy, lower middle class background. And that the evidence will also show, unlike Mr. Jackson mentioned, that at the age of 9 years old, he lost his father to a sudden, shocking death.
At this point, I don't know whether it'll be relevant, but I'm going to allow this during opening statement. If the offer is made that this is what the evidence will show, there may be a theory of admissibility. I'll allow it.
And that he moved here with his mother, Bertha, at 9 years of age. So I don't want any of you to feel that somehow, some way, anything was given to Philip. Quite the opposite is the case. The evidence will show that he had a talent, and he worked very hard at his talent to make an impact in this world, in the world of music, and in the world of entertainment, and in the world of art. So when Mr. Jackson talks about these women, he mentions some of them, and that you're going to hear from some of these women who somehow, some way had a romantic interest in him. The evidence will show you what the reason, what the draw, what the attraction was for them to be interested in Philip. Why were they interested in him? The evidence will show to you that in his way, he was a true and is a true romantic of a bygone era. He didn't chase any of these women. They came to him. They wanted to spend time with him. These were relationships that occurred between him and these women. They have nothing to do with the death of the decedent. Judge Fiddler will tell you what, if anything, you can use with regard to the testimony of the other women with regard to a narrow legal issue in this case. But be assured and rest assured that these incidents to which Mr. Jackson referred go back as far as 30 years ago. At least one of them does, and the rest 20, 25, 18, 12, and 10 years ago. Not one of these women, not one, stopped seeing Philip. Not one of these women prosecuted him. Philip was never charged once for assaulting or hurting another human being. And he's in his 6th decade. Not one of these women came forward to them until after this incident. In this day and age, the evidence will show, with the excessive information that goes around the world, as you see from our friends here in the audience, after February 3 of 03, they decided, and the prosecutors decided, to come together. And they came forward at that time, or they reached out to them at that time. But if you listen to what Mr. Jackson, the prosecutor, said here, they had murder on their mind on February 3 of 03. Their case was de Souza right then and there. They didn't have any need at that time, the evidence will show, for a cause of death. They didn't have any need, the evidence will show, at that time for a manner of death. The evidence will show that when the coroner, who they will call in this case, had some misgivings and some doubts about how the decedent died and wanted some further information about the decedent, the prosecutor's office at that time said no. And from February 3 of 03 to September of 03, there was subtle and direct pressure put on Dr. Pena and some of the others in the coroner's office to declare this death, as gory as it is, as horrific as it is, as egregious as it is, to declare it a homicide. Because as you heard from the prosecutors, there were no witnesses to this. What you've heard from the prosecutors today, excuse me, they don't have cups here though. What you've heard from the prosecutors here today is that this is some continuation of a pattern. The evidence will show otherwise. That this was some evidence of intent on the part of Philip. The evidence will show otherwise. That this was a motive on the part of Philip. The evidence will show otherwise. That there was some malice on the part of Philip. The evidence will show otherwise. The evidence will show that the decedent approached Philip. When she found out who he was, she came over to him. She took him. When you sit back, take in so much, Mr. Jackson made such an efficacious and forceful argument, painted a man he doesn't know as almost a stark, raving maniac. And the opposite is the case. These other women have nothing to do with the death of the decedent. These other women had relationships with Philip. The decedent and Philip were strangers, according to the evidence in this case. And according to the evidence in this case, the decedent, at her own volition, there was no pressure. There was no pressure applied. She decided to come home with him. She found out who he was. You'll hear from the evidence in this case that the decedent, and she should rest in peace, had some difficulties with her life. I told you in the beginning, I will not besmirch the reputation of a decedent. I won't do it. But if it's relevant as to manner of death, I will go into it because it's relevant to clearing Philip of these false charges. And you'll understand and appreciate that she was 41 years old. She shouldn't have done it like that. How do I speak to you, jurors? After you've seen photographs like that, you probably want to strangle me. I don't mean that literally. But you're probably so against us, you think that there's something to it because of 5 words allegedly said to one taking a siesta. De Souza. He was asleep, he claimed at the time he heard the noise. That's what I learned is the term for him now. I'm not faulting him either. But 5 words to one person. That's what they said. They've taken that and they've added, and what's called in the evidence you'll see is like an interstitial filler, like those foam peanuts you see in a box when you get a fancy present from a store. Maybe a clock from Cartier, if you're fortunate, or a clock from anywhere that works. And they surround the item with the foam peanuts so it doesn't break. But here, what evidence will show when you open the box, it's just the peanuts. There is no clock in there. These women are being permitted to testify under the aegis of Judge Fidler. They're permitted to do it. I submit to you that the evidence will show they're being called to assassinate Philip's character. Make him look like something he's not. This is a man whose music changed the world.
Objection, Your
This is a man that...
The objection is sustained. That's going into argument.
This is a man that Hal Blaine, who was on the prosecutor's witness list, said in the 37 years I worked with him, I never once saw him with a gun. I never saw him in the studio doing anything off color. Ever. I've heard the rumors, he said. Problem is, out here, the evidence will show with the insatiable appetite for well-known people, the insatiable news about well-known people. Rumors begin, innuendos start, and stories are started. Fiction becomes fact. Untruth becomes truth. And that's what you'll see. And you'll see that even our great writer from the evidence, Tom Wolfe, indicated that back then, when Philip hit his high note, through the 60s, 70s, and the late 50s, he closed down his non-music life. He became a very private person. And so when you become a private person, then Mr. Jackson can show on the screen that he owned a home in Pasadena. The home in Pasadena didn't have a back door, but they say it anyway. Then he can say that he lived in Hollywood. The evidence will show that Philip never lived in Hollywood. Then he can show a photograph of the Pyrenees Castle, built in 1919. It was called the Pyrenees Castle when it was built, which is a landmark in Alhambra, and make it seem like it's some den of iniquity and it's some private possession, and somehow was given to Philip because he came here from the Bronx with his mother at 9 years old. Nothing was given to him. He didn't mistreat these women. This is an example. The evidence will show that something terrible happened in his home. He was arrested for it, not charged until 10 and a half months later, not indicted until 17 months later, but he was charged with it because the police had murder on their mind. And that's how they went to the house. The evidence will show that when they approached Philip's home, they waited outside for 30 or 40 minutes. You listen to Mr. Jackson, the prosecutor, you think they were storming the Bastille. And they knew from D'Souza, if he was honest, that there was nobody in the house. The decedent died. Shocking, horrific death. Most shocking kind of thing. And the evidence will show you can't point a finger and have somebody pay for that because it happened in his home. The evidence will show that the prosecutor has to prove that beyond a reasonable doubt. Those are not empty words. That's the highest form of proof we have in this whole country. Shadow of the doubt is nice for Mr. Jackson to say.
Objection, Your Honor. This is
There is no shadow of the doubt.
The objection is sustained. You may proceed into opening statement.
Beyond a reasonable doubt, Judge Fiddler will tell you. That's the standard in this country. When they approached the castle and they saw Philip, they claim, according to the opening statement by the prosecutor, they saw him on the second floor. The evidence will show he wasn't doing anything improper. This was a shocking event. This was an event that shocks you to the core. So not everybody, the evidence will show, knows what to do. Not everyone, the evidence will show, knows what to say. Not everyone, the evidence will show, has worked for the EMS or the 911 folks. Not everybody has done that. And the evidence will show in a shocking event, people do things that sometimes are not explainable. And the evidence will show they're not consciousness of guilt, but their consciousness of terrorized innocence.
Objection, Your Honor.
Consciousness of terrorized innocence.
The objection is sustained. Please return to your opening statement and do not argue.
No, he wasn't doing anything wrong. He was just covering up a crime. That's all. Just cleaning up the crime scene. Not doing anything wrong. Nah.
You, the case. Thank you.
So, yes, Your Honor. So, ladies and gentlemen, when they approached the castle, and Mr. Jackson says the policeman gave Philip directives and orders, they told him to put his hands up. He did put his hands up. He invited them in. Said, come in. You've got to see this. There's a dead woman in my home. Whether he had 14 phones or 1,400 phones, the evidence will show how does that change anything. Whether he ran upstairs or walked upstairs or ran outside or didn't go outside, the important thing is at the time of the discharge of the gun, at the time the gun was fired, Philip will prove that to you. She was. Evidence will show that. It's just so hard to after seeing the photographs. Evidence will show that playing with guns and providing a salacious matter can result in death. Instantaneous, the most horrific death. Completely avoidable. Completely unnecessary. A complete waste. But not because Philip is a man of, not because he's successful, not because he had arguments with women 30, 20, 18, and 15 years ago. The evidence will show he never hurt anybody. He was never charged with hurting anybody. He never put a gun in a woman's mouth. He would never do something like that.
Objection, this is argument.
That has become argument. The objection is sustained.
The evidence will show you that. None of the so-called 1101B or incident with gun women to which Mr. Jackson referred will give that kind of testimony. The evidence will also show why they're coming. Why they're coming. The evidence will show that if we were in another site, another place, another city, another state, without the great cachet of Hollywood, without the great cachet of the entertainment capital of the world, and if Philip didn't have a name of major note because of what he's accomplished with his life, they wouldn't be here. They wouldn't be here. The evidence will show some of them peddled their stories to magazines, supermarket tabloids. He mentioned Miss Jennings. She's a freelance photographer. He called her a professional photographer. I like that. I like that. But she's not Philip. And neither are the other women. These were women who were drawn to him, and came back to him after these alleged incidents, to be with him. Some of them even called him after the February 3rd incident. Some of them even communicated with his daughter well after the February 3rd incident. So how is it the evidence will show did they decide to come forward now? What is their motivation?
Objection, this is argument.
That part, the last quoted words, is argument, and the objection is sustained.
The evidence will show, and I know you will look, to see where their heart is. The evidence will show that at times people act a certain way for their own benefit, the evidence will show. You might even see some tears in the courtroom. But some people, when they see another is vulnerable, when they see another is vulnerable, falsely charged with the most serious,
The latter portion is argument. The objection is sustained.
charged with the most serious crime you could be. Former girlfriends, boyfriends, employees, paramours, so-called friends can really give it to you.
Once again, this is our.
Sustain.
Just so it's clear, when you hear from the prosecutor, you get the impression that it is Philip pulled and wanted to go with these women. The evidence will show that he took these women to the finest places. Now he's being punished for it. Took them to the rock and roll induction ceremony dinners. The evidence will show he himself was inducted into the Rock and Roll Hall of Fame some 20 years ago
That may or may not come in. I'm going to overrule the objection at this point.
by his dear friend Tina Turner, who presented him. The evidence will show this is a man who spanned the years from Lenny Bruce through John Lennon. For those who don't know, Lenny Bruce was a political satirist in New York and all over, who spoke out. In fact, he preceded the great Richard Pryor and many others. He used to speak out in a strong way, and he was prosecuted and persecuted.
Objection. This is irrelevant.
The objection is sustained.
So you want to know who this is?
Objection.
The objection is sustained. The jury is admonished to disregard anything where I section disregarded. You may proceed.
And Philip spans all the way from there through the John Lennon era. And you'll hear evidence that he worked with John Lennon. That was his dear friend who was murdered in New York. That he worked with George Harrison. That was his dear friend who died. That he worked with the Rolling Stones. That he worked with all these girl groups. That he extended himself to others. He made livings for others through his talent. He was not a taker, the way he's been described by the prosecutor, but he was a success and a talent who gave to others. That's what he was. Whether he became a private person because he closed off his personal life, his non-music life, as the great Tom Wolfe said, that's a separate part. But that doesn't mean, and you should never accept the thought, which was put to you this morning, that somehow there's evil there.
Dude, quit running into the microphone.
Evil in the castle? Dub the castle? You've heard not one iota of evidence in this case, including my statement this afternoon and including the statement by Mr. Jackson. And if you were to go in the room to deliver a verdict now, you know what the verdict would be. So there's no more problem with having to worry about you prejudging the evidence. Because after today and tomorrow, you will be judging the evidence. But I submit to you, please bear in mind what I say. That a theory that the prosecutor has weaved in this case is just that. It's a theory. The ex-girlfriends who are coming forth have nothing to do with the decedent who he just met. Nothing whatsoever. Some people have arguments and say things and do things. The evidence will show that are not meant for a public forum. It's interesting to hear today about one of them, Miss Melvin, and the prosecutor indicated that she worked for someone of note, and the evidence is going to show that Philip was friendly with Miss Rivers. That was his friend, somebody he knew. That's why he went to her parties. The evidence is also going to show that part of the cachet and the appeal to be around Philip Spector was because of the success he's had in life. And that does not mean, and as I said to you in voir dire, that he's looking for anything from you other than justice. This tough courtroom, where it takes you so long to get up, so long to get down, wait in line for lunch, our offices are not here. This tough building is a temple of justice. That's really what it is, as difficult as it seems to be. This is a temple of justice. And as a temple of justice, you need to understand.
I'm sorry to interrupt. This sounds like it's getting into arguments.
It's getting close, but it hasn't quite got there. I think it's a precursor, so I'm going to overrule your objection. You may proceed.
This temple of justice is here for you to do justice, to analyze the evidence, to evaluate the evidence, to look at it with a careful eye, a judicious eye, to understand and appreciate it, to understand and appreciate why the prosecutor, the evidence will show, is going back so many years to bring up something that you may or may not think is relevant to this case. And Judge Fiddler
The objection is sustained.
will tell you how to use it.
Objection. This is argument.
Sustained. Please, what the evidence will actually show as far as facts go.
When I mentioned murder on their mind, you'll see from the evidence that once the police department had a person of major note, and this has been going on for well over 100 years, well over 100 years out here. Someone of major note had a death in his home, a drowning outside his home. The police have murder on their mind. And so because of that, they did everything they could to take care of Mr. De Souza, who called himself on the 911 tape Souza. He was here illegally. I don't fault him. There are 13 million people who want to come to the United States. He was here illegally, but he was working. I don't fault him for that. I don't fault him for that. I don't fault him for that. You're going to see from the evidence he had some animus and antipathy towards Philip. You'll hear from the evidence that he said to the police in his own speaking terms, and you'll consider and appreciate that this happened over 4 years ago. And he's been in this country under the aegis and protection of the district attorney with their help, and his English is better and is better and is better. And you'll try and think how it was 4 years ago when he first heard these things. And you'll understand and appreciate what they did for him and why. And the jealousy and the animus will be indicated by him on the stand. You'll hear evidence about that. Oh, other customers like to talk to me. Other customers speak to me. Mr. Spector didn't speak to me. Other customers, I went home at 2, 3 o'clock in the morning or 12 midnight. Mr. Spector kept me late. I submit to you the evidence will show that the decedent, not only went there voluntarily, and I don't mean anything unkind about that. Moved her car. I believe the evidence will also, and I submit to you, will show that she had a design of her own. She had a plan of her own. I'm not speaking against her. It's not fair, but I'm here to save a life. She had a design and a plan of her own. The people who worked with her and the people who knew her will indicate some of the difficulties she was having, financially and otherwise. We all do, everybody does. Even Mr. Spector, it would be a shock to Mr. Jackson. Everybody has them. Everybody has them. Difficulties and problems. Problems and difficulties. So the evidence is going to demonstrate to you that she saw an opportunity and she saw something in Mr. Spector and Philip that would be beneficial to her. Beneficial to her. The evidence will show that sometimes an ornamental gun, say it again, an ornamental gun can use for all kinds of things, even though it's unsafe to do. It's unsafe to do. Police themselves, the evidence will show guns. But the evidence will show she was fully familiar and facile with the guns and sidearms. She knew how to use them. And she was a big, strong, strapping woman. I'm not casting aspersions. I wouldn't do it. No matter what, I wouldn't do it. I told you it's not right. But you must consider the woman. You must consider the design. You must consider the plan. This staying for one drink, that's all coming from De Souza. I think I killed somebody, that's all De Souza. The whole case is De Souza and these other so-called victims. One who's a Reggie, and the others who peddled their stories, they're not bad people. Philip didn't know Pelleggi Grosvenor was a when she romanced him, when she spent times romance, a part-time romance, a fling that goes on and off for years, and then ends, and there's animus and resentment, and then you have a problem, terrible problem, because a woman killed herself in your home. And so they come to your aid. And they give a story, a tall tale. That's what this case is. You'll see from the evidence, tall tales. He pointed a gun at me. He pointed it at my face. He cursed at me and pointed a gun. Well, then why do you keep saying them? There's no shrugs in California. Not everything is shrugged off. Why do you keep singing him? Why do you keep taking his money? Why do you keep spending his money?
This is dipping into argument, so the objection is sustained.
So the evidence will show that they kept spending his money. They kept taking his money. Like as Mr. Jackson said, Miss Jennings had a suite, the Carlisle Hotel, a hotel he says he can't go to. Well, I'll take him there anytime he wants. There's nothing off color about the Carlisle Hotel. And the evidence will show they have a piano bar. And some of the most famous musicians, entertainers, and people in Philip's life spend time at the Carlisle Hotel. That's not a bad thing. That's a good thing. The fact that he's talented and successful, they're not bad things. They're good things, the evidence will show.
The objection is sustained. On that note, we will break for the day. Ladies and gentlemen, I need the parties to stay for a few minutes. There's an issue I want to talk about. I'm going to bring you back at 9:30 tomorrow. There may be some legal issues that we need to resolve outside your presence, and we may start late, but I'd like you here at 9:30. All right, keep in mind the court's admonition. We're in recess.
I was muted. I'm sorry. I thought they were done. The judge is still talking. So hang on, let me fix it. You can't argue in your opening and then say the evidence will show after you argue and say it's not argument. Argument is argument. You can't just tack the evidence will show on the end of it. It's still argument. You're not allowed to argue in your opening. He he got thrown for a loop when whatever he wanted to do got disallowed, I guess.
Yeah, happy to change my opinion. The one thing I will say, because I don't want to get into a lot of time consumption in me or the prosecution running to do research, if you are going to file a motion in the morning, get a fax number from them and fax it over, it's ready to go. So they have notice and they can respond to it, and I can be prepared and get it to me as quickly as possible. Okay? Now, there's something you wanted to raise.
Well, I don't feel like doing it. It's not my style, but
Good.
I don't think they mean any harm to the prosecutors. But they chat with one another when I'm up there. That's what I want to hear.
Actually, in California, it's supposed to be there.
I don't think they do it deliberately. It's not.
It's a distraction to Mr.
Okay,
Cutler. We
that's
will-
fine. They won't get
That's, and I know they won't. So
There we go.
So you want to
9:30
tomorrow?
9:30 in the morning.
Thank
Thank you.
Oh, there I am. Yeah, this guy, I was warned about this guy because Flash Fan, who was not here today, I was surprised. I don't know what just happened. That guy, I was warned about that guy. Flash Fan, this kid, Flash Fan, he lives in DC. He's 25 years old, and I swear this kid knows I can call him a kid because I'm old. We've been friends for a couple years now. He's like one of my OG, like way when I first started my channel. He was, I think we met before I started my channel. And he knows more cases than I do. He knows specifics about cases. I don't know where he is. That's the thing. He's the one that's been wanting me to do this case forever. And he popped in here yesterday right as I started, and he started like giving me facts about who was who and what was what. And no sign of him today. But he warned me about this guy. He goes, wait until you hear this guy. And he was right. This guy, woo, piece of work. He just rambled for 45 minutes, and his opening statement is in 3 parts, I think. So that, yeah, he is. He's amazing, Haley. He is. I don't know how he remembers it all. He is amazing. Absolutely amazing. So I was surprised that he wasn't in here again today. But yeah, so there's 2 more parts of the opening. If he's just gonna freaking ramble, but we got to go through the boring stuff to get to the good stuff. So I will see you guys. Oh no, I won't see you guys early in the morning. So no Phil Spector tomorrow, guys. Sorry, tomorrow's my nerve block. So I will be, I won't be having fun tomorrow either. It's not like I'm going to Disney or anything. I will be face down getting needles in my back. So I won't be having fun. So don't feel like I'm leaving you guys for anything special. Thank you, Lori. Yeah. No, we're doing Karen Reed today. Thank you, Haley. If it doesn't last all day, if Karen Reed doesn't last all day, we will go to the corn rake case. But we have to do. Thank you, Carla. We have to do Karen Reed because I did, like I said yesterday, for those who weren't here at the end of the corn rake case, I watched her first trial, gavel to gavel. I was a mod on another channel, so I wasn't streaming trials yet. So I'm really, really invested in this case, and I'm going to stream the new trial. So I really, really want to watch this hearing. Oh, yes. Oh, wrong one. Yes, 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 yes. So the hearing starts at 11. I'm going to go live at 10:30 because last week when she left the bench, whatever we were watching it on, I don't remember if it was Law and Crime or Court TV or whatever. When she left the bench, they cut the feed, and I didn't even know that she came back. So, um, um, I downloaded like it was only like 5 more minutes because when she came back, she dismissed the hearing. So, um, I downloaded it. So at 10:30 Eastern, 10:30 Eastern. So that threw me because I'm monetized. I'm not used to being monetized. I'm sorry. That's why I got all like weirded out. Um I am actually like I'm not monetized as far as like views and ads and that kind of stuff because I haven't set that part up yet. I haven't set up memberships yet. I can get super stickers and super chats, but that's all I can do right now. No, that's fine. That's why you're a mod. It freaked me out for a minute. This is so new. It's just, okay. So, anyways, what was I saying? Oh, okay. So I downloaded like the, um, the 5 minutes that we missed of her coming back to the bench. So we're going to watch that at 10:30 and then I'm going to explain because at the time I didn't even know what was going on. I didn't understand the implications of what had just happened. And I tried to watch stuff about it to understand it a little bit more. I didn't get to watch as much as I wanted to, but I watched enough to know what happened. So I'm going to talk about that a little bit. And, if you guys want to put some input in, if you're going to watch it with me, put some input in. And then we'll watch today's hearing. And I hope, I'm worried for Alan Jackson. I really, really am. I hope everything works out like it should because I don't want this woman to go to prison. I don't think she did anything wrong. Okay, so that's going to start. I'm a little tired, but I am better today. Um, and hopefully after tomorrow, I will be a lot better. So, okay, so that's going to start at 10:30. So I'm going to take a break for about an hour and I will see you guys over there. And thank you for coming out. I am so happy that you guys like this. I was really debating about whether to do it at all and I'm just so happy. I cannot tell you guys how happy you guys have made me that you like this cuz I was just thinking no one's going to watch this. Oh, thank you, Lori. Cuz yeah, my hair was a mess yesterday. It was a mess yesterday. So I did it this morning and I was like, yay, I'm having a good hair day. I feel better. So I was doing good. I like my schedule has changed because I started getting up earlier to be in Kathy's live stream. And then I've like gone to bed earlier. And so like my internal clock is changing. But then Sunday I took a nap in the middle of the day. And then I had trouble falling asleep Sunday night. So yesterday I was really tired. So I've screwed up my internal clock. But I feel a little bit better today. So and my back is not hurting me as bad today. So I think the weather though, because it was like I don't think it ever rained, but it was like overcast and dark, like it was gonna rain all day long. And you know how that messes with fibromyalgia. So yeah. And for some reason I've got that one Christmas song from that album that like the famous Phil Spector Christmas album. It's stuck in my head now. I want it out. I don't know why it got stuck in my head. Okay, so I'll see you guys later. I love y'all. Bye. Oh, I'm sorry, Lori. Okay, see you guys later. Have a good day if I don't see you later. Bye.